We're going to talk about the Supreme Court. Supreme Court of the United States issued a new set of orders today, and in those orders, we saw an opinion by Judge Thomas as it relates to Twitter and free speech, which is very interesting because Thomas is one of the more conservative judges, and this has been an issue that has been floating around for some period of time. I want to do a little bit of backstory on this. So if you remember, back in 2017, Donald Trump was still the president. He was still on Twitter, and he blocked some people on Twitter. And what happened? There was an organization known as the Knight First Amendment Institute, and 7 people that Donald Trump had blocked, and they sued him. They said that they violated Donald Trump as the president. They violated their First Amendment rights as citizens by blocking them, right? We're citizens. We have a right to express ourselves. First Amendment, free expression. Donald Trump, the president, an elected official in office, blocked them. That's a deprivation of their rights. So they went and sued, and the district court said, we agree with you. Donald Trump is violating your rights, and the U.S. Court of Appeals upheld that ruling. Said, yeah, you're violating their rights. So what happened? Well, Donald Trump's not the president anymore. And this case is now moot, is what the Supreme Court says. So what happened before we got to this moment in time, there was a U.S. Solicitor General, a guy by the name of Jeffrey Wall, who was the top lawyer, and he was working for the Donald Trump administration. And when the Second Circuit Court of Appeals said, yes, also you cannot block people on Twitter, Mr. President, he said, well, why don't you guys take this up to the Supreme Court? So they did. They took that Second Circuit position up, and the conversation was about asking the Supreme Court to weigh in on elected officials' conduct. What can an elected official do on Twitter, on social media? Right? This is the court asking what the president of this country can do. It's kind of a big deal. You don't want a Second Circuit court or a district court saying, well, Mr. President, sorry, you can't block people with your Twitter account. You have the president going, what did you say? I just appointed you, buddy boy. Right? So you have this sort of sacred division of power. You want the Supreme Court to weigh in on that, not a lower level position. So that's where we're at. Now the Supreme Court has in fact heard this case. So this was appealing itself all the way up, and we have an opinion today that came out. Kind of. Not really, but kind of. And this might give us a little hint about where this is going. And so I want to run through this a little bit. Here is the opinion as it came out today, decided April 5th, 2021. And it says it's in the Supreme Court of the United States. And you're going to notice it says Thomas J. concurring. So that's just Judge Thomas. And you'll see here, this says on petition for writ of certiorari, it's Knight's First Amendment Institute. They were originally suing Donald Trump, but now he's not in office anymore. So now they're suing Joe Biden, who is the president. So it's Knights of America, or Knight's First Amendment Institute from Columbia suing Joe Biden. And you're going to notice that this is the majority opinion. This is the whole opinion right here. This is everything that we've got. It says the petition for a writ of certiorari is granted. So the Knight First Amendment University was the original plaintiff here. They sued the president, went up to the district court. They won, went up to the Court of Appeals. They won. Trump's people took this up to the Supreme Court. Supreme Court says, we're going to hear the case. We'll take it. Doesn't happen often, but they did. And what did they say? This is all you got. They said, yeah, it's granted. We're going to hear this case. By the way, the judgment is vacated. The case is remanded back down to the Court of Appeals with instructions to dismiss the case as moot. Moot. Okay, we heard a lot about that word, moot, moot, moot. And ripeness and all of these standing issues from the election litigation that was taking place right after November 3rd. And so they're saying this is moot. This is the whole opinion. So this is not even really what's important. What did they do? They accepted the case and they said it's over. He's not president anymore. There's nothing to solve here. So dismiss the case. We're not going to make any final new law or give you any clarity about this. So Judge Thomas then comes back out and says, hey, before you send that order out, I got some things to say about this issue. And that's what we're going to go through right now. So here is Judge Thomas writing a concurring opinion. And he's talking about Twitter. He says, when a person publishes a message on a social media platform, Twitter, the platform by default enables others to republish or retweet the message or respond to it. The user who generates the message can manually block people from republishing or responding. Donald Trump did that. He blocked several people. They sued. Second Circuit upheld it. They said that Trump violated the First Amendment and onwards. Because of the change in the presidential administration, the court correctly vacates the Second Circuit's decision. So there's a different, now Biden's in office. So just get rid of this case. There's nothing we can do. It's over. If you are successful in your lawsuit and Donald Trump unblocks you, guess what? He's not president anymore, and he's not even on Twitter anymore either. So what do you want us to do anymore? It's moot. Go away. He says, respondents have a point. Well, let's back up a little bit. He says, I write. So why is he writing this opinion? He says, I write separately to note that this petition highlights the principal legal difficulty that surrounds digital platforms. Namely, applying old doctrines to new digital platforms is rarely straightforward. Respondents have a point. For example, that some aspects of Trump's account resemble a constitutionally protected public forum. So he's siding with the people who got blocked. He's saying, yeah, it kind of does feel like a public forum when you're on Twitter. But it seems rather odd to say that something is a government forum when a private company has unrestricted authority to do away with it. So we talk about this, right? If free speech and a lot of your Bill of Rights, it's to restrain the government from encroaching on your freedoms, but not private companies. But the people who are saying that Donald Trump blocked them, that he was violating their rights, he's not a government. Twitter's not a government entity. He's a government politician. So the court is coming back out and sort of opining on this, but they're not reaching the true issue here. They said, well, just dismiss it. It's moot. But what about the issue? What about, can a president block somebody on Twitter? We still don't know. We don't know the answer to that because they just dismissed this case. Judge Thomas is telling us maybe we should think about this. He says the disparity between Twitter's control and Mr. Trump's control is stark, to say the least. Trump blocked several people from interacting with his messages. Twitter barred Mr. Trump not only from interacting with a few users, but they removed him from the entire platform, thus barring all Twitter users from interacting with his messages. At the time, he had 89 million followers. And this was the same point that I made back when this happened. I said specifically, not only is it Trump's inability now to communicate with 89 million people, but what about 89 million people who are relying on this medium to communicate or to hear from their president? So Twitter was saying he doesn't have a right to communicate his message out. But what about the people who have a right or at least an agreement with Twitter to receive those messages? Right? The Second Circuit and the district court said, yeah, that's a pretty big problem. Twitter just removed him entirely, though. Under its terms of service, Twitter can remove any person from the platform, including the President of the United States, at any reason, for any reason, or no reason. That was effective June 18, 2020. This is cited in a Supreme Court case. The Twitter company can remove anybody at any time for any reason, including a president, from the Supreme Court. This is not the first or only case to raise issues about digital platforms. While this case involves a suit against a public official, the court properly rejects today a separate petition alleging that digital platforms, not individuals on those platforms, violated public accommodation laws, the First Amendment, and antitrust laws. The petitions highlight two important facts. Today's digital platforms provide avenues for historically unprecedented amounts of speech, including speech by government actors. Also unprecedented, however, is the concentrated control of so much speech in the hands of so few private parties. We will soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructure, such as digital platforms. Yeah, never seen anything like this. If you notice, on our channel, we talked about the Digital Bill of Rights. We had a couple Saturday workshops on that. Kind of a fun thought experiment, knowing that this is going to be something that is relevant in all of our lives. And it's going to continue to move this way, right? Facebook's going to get bigger. They're going to keep gobbling up other companies. Same with Google, same with Twitter. Sort of accumulating more and more assets and clamping down on their control as this continues. And Judge Thomas is rightly, I think, acknowledging that this might be a pretty big problem. It, in fact, already is a pretty big problem. And he goes on. He says, on the surface, some aspects of the Twitter account resemble a public forum. And so you're going to notice here, this says section 1. So we're going to be talking a lot about public forum. What is a public forum? It's a designated public forum. It is a property, quote, that the state has opened for expressive activity by part or all of the public. Right? So Twitter doesn't sound like that. The state has not opened it. And they haven't done it for expressive activity of all of the public. It's Twitter. It's a private company. Mr. Trump often used the account to speak in his official capacity, and as a government official, he chose to make the comment threads publicly accessible, allowing any Twitter user to respond to his post. But the Second Circuit, they concluded that Trump's Twitter account was a public forum. That it was is in tension with, among other things, the frequent description of public forums as government-controlled spaces. So the Second Circuit said that Mr. Trump actually did have to unblock those people and allow them to communicate. Judge Thomas says unbridled control of the account resided in the hands of a private party, which is Twitter. The First Amendment doctrine may not have applied to respondents' complaint of stifled speech. Whether the government use of private speech implicates First Amendment often depends on government's control over that space. So a government agency that leases a conference room in a hotel to hold a public hearing about a proposed regulation cannot kick out participants because they express concerns about the new regulation. Subsection A. If a part of the problem is private concentrated control over online content and platforms available to the public, then part of the solution may be found in doctrines that limit the right of private companies to exclude. So that's the next question then. If you are a private company, and so I've thought through some of this in our digital Bill of Rights conversation. And so my perspective on that was there are certain things in this country that we do not allow you to do because we have decided as a country that's just too wrong. Okay. Slavery is one of them. Segregation is one of them. We have decided as a society that if you may not like one particular race, but you can't discriminate against them. If they want to come into your sandwich store and buy a sandwich, you can't say, I don't like your skin color and get out, right? That might be your free expression. That might be your freedom of speech, but that's too bad. Okay. You might have a bus entity that says all of the black people sit at the back, all of the white people sit at the front. That's a private company. They're operating on public roadways or whatever. Find an example of that. Find the private sandwich shop owner who says whites sit over there and blacks sit over there. No, we don't. That's not allowed in this country. We say the answer is no. Those are private companies, but we elevate the standard up. We say no. Your freedom of speech, your freedom of association, your right to serve that sandwich to whomever you want does not outweigh equality and desegregation. And so we've already done this. We've already prioritized certain rights in this country, civil rights. And so here, my position was that speech is so paramount, it's the First Amendment, that the standard on that should be raised, and other private entities should not be able to drop below the standard of free expression, free ideas, and some of the protections provided under the First Amendment. They cannot drop below that standard. Just like a private company can't go and enslave a bunch of people. It's not lawful in this country. 13th Amendment. And many others have said that certain types of discrimination are not allowed. So why does that not apply to free speech and private companies? We want to raise that standard up. That's been my argument. Let's see what Thomas has to say about it. So he says, historically, two legal doctrines limit a company's right to exclude. So let's go through this. First, our legal system and its British predecessors had a concept known as common carrier to special regulations. He goes through some of the history here. Some scholars have argued that common carrier regulations are justified only when a carrier possesses substantial market power. Others have said that no substantial market power needs to exist. I think it's pretty obvious here that you could easily say Facebook, Google, Twitter, they all have almost monopolies on their market space. What other microblogging platforms can you name? Twitter, that's it. Parler, kind of. That's it, though. Google, what else do you have? Bing? Facebook? They own Instagram. What else do you have? TikTok? Right? Amazon? Who competes with Amazon? Walmart? Maybe? They're essentially monopolies. They have all of the power. Internet platforms, of course, have their own First Amendment interests, but regulations that might affect speech are valid if they would have been permissible at the time of the founding. So they're going to this case, which was decided back in 2010. The long history in this country and in England of restricting the exclusion right of common carriers, may have similar regulations today from triggering heightened scrutiny. especially where a restriction would not prohibit the company from speaking or force the company to endorse the speech. So we're seeing some modifications here. All right, some complicated stuff going on here. They're talking about an exclusionary right. So you're a company, you have the sandwich store, you have somebody who comes in a particular race that you don't like, you exclude them. We as a society have said, no, you can't do that, right? That's discriminatory. People can have equal protection or due process claims. They can sue you into oblivion, and people are doing that, right? We're seeing that right now with the gay wedding cake or whatever that story is about, right? These are things that are being litigated in court. So what he's saying is, when you go back and you talk about this right to exclude, what are the rules surrounding that? When do you get to invoke that right? How does this all work? And he says one of the things is where a restriction would not prohibit the company from speaking. So it's not going to limit their ability to speak. So forcing people to be on Twitter, not kicking Trump off, does not prohibit the company from speaking. And it does not force the company to endorse the speech. So those two things are met. There is a fair argument that some digital platforms are sufficiently akin to common carriers or places of accommodation to be regulated in this manner. So as long as the person who's getting booted off their platform, if they weren't forcing the company to speak and they weren't doing something to interfere with their ability to speak, and the company doesn't have to endorse their ability to speak, then no, they might be a common carrier, and you can't boot them off. He also says, in many ways, digital platforms that hold themselves out to the public resemble traditional common carriers. Though digital networks instead of physical, they are at the bottom of communication networks, and they carry information from one user to another, just like anything else. Traditional telephone company laid physical wires to create a network connecting people. Digital platforms do much the same thing. He said the analogy to common carriers is even clearer for digital platforms that have dominant market share, which of course are Facebook. Facebook's suite of apps, valuable largely because they reach 3 billion people. Google has 90% of the market share. Google brought in 182.5 billion total. That's 40.3 billion in net income. That these companies have no comparable competitors highlights that the industries may have substantial barriers to entry. Yeah, because they have the network effect. Right? We've talked about this. Once you get that big, you pull up the ladder. You climbed up a nice ladder that everybody laid out for you. When you get to the top, you pull it up so that nobody else can start their own companies. This is exactly what's happening here. Exactly. It's clear. Okay. Amazon eliminated an entire competitive industry. They removed Parler off Amazon Web Services. Do you know who contracts with Amazon Web Services to run their servers? Twitter does. So Amazon was contracting with Twitter for a multi-year, $100 million, whatever, how many millions of dollars to run their operations. And Amazon boots off their biggest competitor at the time. How can anybody come in? How can anybody work their way up the industry if you have this collusion among the big people up top? Problem. To be sure, much activity on the internet derives value from network effects, which is what they talk about. But dominant digital platforms are different. Unlike decentralized digital spheres, such as email, control of these networks is highly concentrated. We got Zuckerberg, we got Larry Page, we got Sergey Brin in the house. Much like a communications utility, this concentration gives some digital platforms enormous control over speech, as we saw in this last election. Blocking a listing, not running the Hunter Biden story, Amazon banning books, Twitter can narrow a person's information flow. Google search algorithms can just suppress content by de-indexing or downlisting a search result. They control the whole friggin' country, folks, the whole country. And the politicians know it. So does Judge Thomas. Every time that Congress has a hearing, Jack Dorsey comes in, Sergey Brin comes in. Now, he doesn't even come in. Sundar now comes in. Those guys are above the fray. Zuckerberg, yes, Senator. Yes, Senator. Yes, Senator. Hey, Mark, somebody's pressing the yes, Senator button behind him. Okay, because they know it's irrelevant. These Congress people have no idea what they're talking about. They couldn't find the like button if you paid them $1 million. They are oblivious. They know. They run the whole thing. That's why they can go into these Congress people and lie to their faces. Hey, is it true that you're doing this activity? Oh, no, not at all. Wake up the next morning, they just did it to 1,000 more people because they are operating with total immunity because our government is incompetent. And here is Judge Thomas trying to do his part. He says it changes nothing that these platforms are not the sole means for distributing speech or information. A person always could choose to avoid the toll bridge or the train and instead swim the Charles River or hike the Oregon Trail. But in assessing whether a company exercises substantial market power, what matters is whether the alternatives are comparable. For many in today's digital platforms, nothing is. And if it is even remotely comparable, they just take it off the internet like Amazon did to Parler. Even if digital platforms are not close enough to common carriers, legislatures might still be able to treat them like places of public accommodation. So now what he's trying to do is create a framework in which to fit this problem. And because he's an originalist and somebody who's looking at the language as it was written and as it applied under the founding fathers, he's trying to craft a solution that is sort of stacked on top of some of these old doctrines. Here, the public accommodation space. What else do we have? Once again, the doctrine, such as a public accommodation that reduces the power of the platform to unilaterally remove a government account, might strengthen the argument that an account is truly government controlled and creates a public forum. So he's making these analogies between private and public forums. The similarities between some platforms and common carriers and places of public accommodation may give legislators strong arguments, and so he fleshes some of that out. None of this analysis means, however, that the First Amendment is irrelevant until a legislature imposes common carrier or public accommodation restrictions. Only that the principal means for regulating digital platforms is through those methods. Interesting. Some speech doctrines might still apply in limited circumstances, as this court has recognized. Although a private entity is not ordinarily constrained by the First Amendment, he's citing U.S. case law, it is as if the government coerces or induces it to take action. The government itself would not be permitted to do so, such as censor and expression. All right, so this is all government stuff. There's no threat is alleged here. What threats would cause a private choice by a digital platform to be deemed. All right, so a couple other things. This is the last page here. The question facing the courts below involved only whether a government actor violated the First Amendment by blocking another Twitter user. That issue, at least to some degree, turns on an ownership and the right to exclude. The Second Circuit feared that then President Trump cut off speech by using the features that Twitter made available to him. But if the aim is to ensure that speech is not smothered, then the more glaring concern must perforce be the dominant digital platform themselves. As Twitter made clear, the right to cut off speech lies most powerfully in the hands of private digital platforms. The extent to which that power matters for purposes of the First Amendment and the extent to which that power could lawfully be modified raise interesting and important questions. This petition gives us no opportunity to confront them. Very interesting opinion. And it sounds like he's going back to some of the common law underpinnings of American jurisprudence, specifically the public accommodation rules and the public forum rules, which is an interesting way to interpret this. And I like it. I like where it's going, because I think that these tech companies have way too much power, and they know it, and they're acting with impunity. All right, so let's take a look at some of the questions over from locals.com. The name of our community over there is called Watching the Watchers. And it looks like we have a couple of these who are chiming in. News Now Wyoming is in the house, says, I still don't buy the argument about First Amendment rights being violated by blocking them. If someone gives a speech and there are protesters, that person doesn't have to hand the protesters his microphone. So by blocking them on Twitter, he was removing that microphone that his many millions of viewers saw. They could still say what they want, just not with his mic. So, if I have to pick a side on this thing, I am pro not blocking anybody. If you're a government official, no blocks and no bans. I am more pro free speech. So if Donald Trump wants to comment on something or post something on Twitter, somebody wants to blow him up in his replies or his comments, that's fine. I mean, maybe a block could just mean, look, tech can accommodate this stuff. If Trump doesn't want to see it, why don't I just block it for me? So I don't see that stuff. This person's a troll. They're annoying me. It seems so ridiculous we're talking about this, but it's like critically important. All right. We also have a next question. Jeremy Matrita says, if it was ruled to be wrong for blocking people on Twitter, then how is it okay for Trump to be blocked by Twitter? It's a great point, Jeremy. It's a good question. You should ask Twitter about that. They keep talking about free speech and they don't want to minimize people's involvement. They want to bring us together by banning people. Liberty or Death says, I love me some Justice Thomas. His opinions like this one are like playing poker with the gambler. I see your point and raise you another. It was rumored that Alito and Thomas were considering retiring this or next year. I hope not. Oh my gosh, I hope not. HI's to maybe here's to wishing they stay until Trump is back in or DeSantis is behind the resolute desk. Can't imagine who Kamala would appoint. Yeah, that would be a big problem. Alito's pretty young. Thomas is getting up there, but Alito's pretty young. Hopefully they stick around for a while. We have Jeremy Matrita says, I believe Twitter commits digital homicide when they ban users from their platform. Yeah, you know, I think that you're right. And people are starting to reorganize a little bit out there. It's going to take some time. I mean, we're not going to see a Twitter alternative in the next 12 months, but we're going to see the roots of one start to take hold. And that will be a good thing. Want to Know says, Rob, how is it discrimination to have to show ID to vote, but not to get immunized? Can police hold you still for 24 hours to prove identity? How does one get a job under INS rules without ID and a social security card? Well, how do you get a bank account without an ID? How do you get on an airplane without an ID? I mean, everything requires an ID. The idea that you don't need this to vote is just asinine to me. I don't know even how they justify that, other than saying it's voter suppression. I get that. I mean, I get why they say it, and I get why they want it to be such a low threshold, because if nobody has an ID, you can just go round up votes. Doesn't make any sense. We have Boom Boom for Love says, how are they going to keep the riffraff out of the new platforms like Trump or Lindell? What's to stop the left from trolling us over there and then canceling us because we are speaking the truth and not being censored? Good question, Boom Boom for Love. Boom Boom. I think that this is an issue, if I can be candid about this, that is going to be solved by blockchain, by decentralized social media platforms, and by new technology that's going to solve this problem. All right, people are tired of I'm tired of this. I don't know if everybody is, but I'm tired of it, of having the news sort of digested for me. It's like those birds that, regurgitate. They consume the little worms for their children, then they cough it up and they yak it into their kid's mouth. That's what the news media is. They go through a bunch of stuff, they digest it, they regurgitate it and vomit it back in our direction. And I'm sick of it. I'm tired of it. And I think a lot of people in this country are. And so if the Facebooks and the Twitters are going to be running their networks the way they want to run them, people are going to just bail out. And I think that's already happening. And they're going to set up shop somewhere else. And I was talking about Balaji Srinivasan. I listened to him all weekend long about his idea for this new concept of what's called a network state. You go from a God state where people are sort of under the rule of, maybe the old Catholic Church or the old Lutheran churches or whatever, right? All of these different sects, people sort of identify with their religious organization. But then society evolves. We don't need that godlike container anymore. Now we need a nation state container. So we got the United States and Russia and China and Mexico and Canada and all of these different countries around the world in a nation state. But there's a next evolution that's coming down the road, and it's going to be the network state. It's going to be based on blockchain. It's going to be decentralized, and a good segment of this world is going to grow out of the nation state community into the network state. And this is the solution to this problem. And I've been saying for a long time that it's going to take conservatives and Republicans and libertarians and free-minded people some time to work themselves out of this current system. And it is going to take time. It's going to take a whole generation. But the groundwork is being laid right now. It's a crazy world. And it's very interesting. And I think there's a lot of promise to that. So rather than thinking about how are we going to get and build up the next platform, the next Twitter, the next Facebook, the next Periscope, whatever. How about that? How about we just have a social network that is decentralized and doesn't even have a company? How would that be? Okay, it's run by other users. There is no Google. There is no censorship. The framework for that is being laid right now. It's going to be an exciting time. Next up, let's take some more questions. We've got, my slides are out of order again. Let's go back over here. Next up, we have Chris Wiseman says, it's a tough stretch to call a bakery a public accommodation for civil rights purposes, but social media platforms are not. I think that if the federal government can regulate airwaves, telephone, energy grid, the internet, and the platforms built on the internet infrastructure are perfect candidates for common carrier status. Unfortunately, This means they capture the space. The unintended consequence is regulatory capture and allowing them to keep out new market entrants. Yeah, it's a great comment, Chris. Thank you for that. Brilliant comment. And I think right on the mark. And that's kind of the point. You know, we hear a lot of these tech companies like they care about the little guy. They're at the top. They pull the ladder up. Nobody else can get in, which is why we need an alternative system. We have Nadar Blasier says, I don't get why it isn't as simple as changing Section 230 to say that these tech companies cannot be held liable for what users put on their site as long as they do not violate the user's constitutional rights. Then their excuse of being liable is irrelevant. I totally agree with you. This is not that complicated of a fix. The problem here is that nobody really wants the fix, and I think that nobody really wants to talk about the ultimate problem, which is that these companies want censorship. They want to control the narrative. They did a lot to do that. Mark Zuckerberg spent tens of millions of dollars literally influencing the election on record. The Chan whatever initiative. We talked about it back on this channel. We talked about where the money was going and how it was being funded, and we drew arrows to where it was going. Here. Okay, they want to influence the election. They want to have this type of control because it's power. Yes, they're making money hand over fist. That's fine. They got enough money. Once you get 50 billion, I'm told that's enough. You got enough. So what else do they want? They want influence and power. And so they get that by keeping things the same, because a lot of the ladders have already been pulled up. Amazon, right? They made it to the top, not having to pay sales tax. They got big. The rules changed. Now they pay sales tax. So the other guys who also want to get big by not paying sales tax for a good portion of their founding, doesn't work for them, worked for Amazon, but not for everybody else. So that's what they want. It's part of the plan. It's part of the structure. We have Besimiento says, I can't believe that no other SP justice joined Thomas in his opinion. Well, Thomas is kind of the lonesome wolf out there. We have Joe Snow says, my local PD has me blocked from commenting. I've sent them precedent regarding this, and I'm still blocked. Hey, you should send him the Second Circuit ruling. Say, hey, there's a court of appeals on this thing. Take that up. Take it up to the Supreme Court. That's funny. No Doubt says, the division between public and private brings up an interesting issue. Does a government official get protection on these platforms, but someone who is not a government official, but who wants to be, does not get the same protection? Well, right now, we don't really know. No doubt. Right now, Supreme Court hasn't said. They just said, hey, that case is going to be dismissed. It's moot. We have no clarity on it. The Supreme Court has been just useless on a lot of the topics that we talk about on this channel. They're talking about other stuff, but nothing that we care about, right? They gave us no guidance on whether a state legislature can allow the provisions that govern their elections to be usurped out from under them by the executive branch or by the judicial branch or even by committees like the Secretary of State or any of these settlement agreements. No answers on that. Trump lawsuits, no answers. The Attorney General lawsuit, no answers. We want to know, what can we do about big tech? No answers. It's moot. It's dismissed. We'll deal with it later. What are we doing over there? Oh, it's a disaster. So we don't know, no doubt. We don't know about how any of this stuff works because there's no guidance on it. Right now, it's status quo. That's what we know. Supreme Court says it's status quo. Sasha Sisha says, hi, Robin, Miss Faith Joy. Twitter will block someone talking about an election F word, but you can have underage sexual stuff on Twitter. That won't take it down. They won't take it down. Even after the victim requests them. It's ridiculous. Yeah, it's gross. All right. We have Chris Weisman says, it will be interesting to see if Knight Center takes this decision and demands that YouTube force the White House account to keep the downvote feature and reopen the comment section. Weird how the most popular president in the U.S. has comments turned off and always gets ratioed. You know, I saw that. And I actually went over to, it's the White House, right? The White House channel on YouTube. Comments are turned off, massive amounts of downvotes, and it's on like every video. It's not just, one video. I was thinking that maybe this was something where there were these trolls who were, sort of organizing these downvote campaigns. So the White House would post a video. They would post it over to a forum. Hey, Sleepy Joe posted a new video. Go downvote that. Everybody on the forum would rush over to YouTube and downvote the hell out of that. But YouTube, according to their rules and according to their Twitter account, they say that they are monitoring the downvotes for spammy downvotes. So in other words, if you don't watch the video, if you just show up on a channel, you don't click play and you just hit the downvote button, well, they're going to know you didn't watch it. And so they're not going to count that downvote. But these are downvotes that just stay. People are watching this stuff and clicking the downvote. They don't like it, which is strange for somebody who got more votes in history and everybody loves and he's whatever. We got Ma Fox says, the real problem is that Twitter is too big. The solution isn't to limit what a private company can do with their property, but to expand the markets and promoting competition. I feel like restricting them would do the opposite. Yeah, so I understand your point there, Ma. I think that I think that they are largely protected by Section 230. So Section 230, I think, was created back in the late 90s when the internet was a new thing. The internet's not a new thing. One of the underlying justifications for Section 230 was to prevent them from liability so that they could grow, and blossom. Now they're the biggest companies in the world. Now they have it all. Do they still need that protection against civil liability? I'm not so sure that they do. And right now, they're the only people with the market share to essentially control the market, whether there's new entry, barriers to entry or whatever. They keep the gate closed so that nobody else can come in. I'm not real sure what the answer is, but I do know that I like that Justice Thomas is talking about a solution and a legal framework. And I also think that free speech is so important that it's just like the segregation conversation. You can't segregate people because we value equality more than we value segregation. You can't ban people for political speech because we value political speech more than we value you not having a couple data points in your software code from some person that you don't think it should be on your platform. I just think that if I have to take a side, I'm going to be more free speech, pro expression, because I just don't think it's as dangerous. And I think that the dangerous conversation was just a fib anyways, because they're talking about dangerousness, but they're still banning Donald Trump when he's saying things that are not dangerous. It's not about speech or dangerousness. It's about banning your political enemies. And at this moment in time, I think that if you're on that side of favoring banning of anybody, you're closer to that category than the free speech people. And I mean the censorship category. It's not a good category to be in. I think it's on the wrong side of history. We have Sasa Shisa says, power is domination, control, and therefore a very selective form of truth, which is a lie. It's a good question there. Good comment. We got Faith here who says, from Jeremy, says, in keeping with the news and animal kingdom analogies, I would argue that the news media craps out stories more like how the civet cat eats coffee beans, and then people make coffee from the beans after they have been through the cat's digestive system. That is a much more visual analogy than the one I used, which is the regurgitating bird. Vomit it out into all of our mouths. Brian Stelter is regurgitating food for us. We have Osak says, hey, Rob, hypothetical question. Could someone sue the police under the First Amendment violation if the person reported a crime, was then arrested and charged and accused, but later found out to be the victim and not guilty of the crime? Police are a government entity. They did punish someone for speaking up. So it's a good hypothetical question, Osak. I think it's a little bit too broad. I mean, really the answer is, yeah, you can sue anybody for anything. The follow-up question there is, well, what are the damages and is it worth a lawsuit? So if the police tell you to sit down and shut up, do they really violate your First Amendment rights? Maybe. And if you sued them over that, maybe you'd win, but what would you get? What was the damage that was caused? What was the harm of you not being able to speak out? And you have to go and ask for damages for that and get compensated accordingly. So typically on these types of claims that are just sort of vanilla First Amendment claims, it's not worth the lawsuit because you're not going to get anything. You're going to come out of pocket to spend, 50 grand, 100 grand on suing a government entity and not win anything. So nobody does it. Last question on this segment comes from Mafox. Says, a little off key, but I just remembered, do you feel like felony murder rules are applicable with assault charges? Or should the predicate require at least aggravated assault to be considered a valid predicate? Does it go against the idea of death in the commission of particularly violent felony to use aggravated assault only as... This question is complicated. Okay, it's a very complicated question. So we can address that later, but basically what he's talking about probably is the George Floyd case and about whether felony murder, which typically requires an underlying felony offense. So the example would be, if you use the bank robbery example, that we often use on this show. Somebody's a bank robber. They're the getaway driver. Somebody goes in to rob the bank and somebody dies in the robbery. The person who was driving the getaway car is charged with felony murder because somebody died in the bank. The underlying felony was bank robbery. That somebody died in the commission of that felony. Therefore, the getaway driver is charged with felony murder. You have a separate felony that happens because you were involved in that. You get charged with an underlying felony, even though you're not responsible for the death of that person. Okay. High level. In the Derek Chauvin case, same situation. He's being charged with murder for doing something to somebody else. The question is, what was the underlying felony? Was it the bank robbery? And remember, in the bank robbery example, we're not talking about the person getting shot inside. We're talking about the bank robbery. During the commission of the bank robbery, which was its own independent felony, somebody died. So that is the basis for felony murder. In the Chauvin case, what they're saying is that Derek Chauvin, the underlying felony was the assault on George Floyd. But how do you kill somebody without assaulting them? You have to do something to their physical body, right? You either put some poison in their food. That's a physical touch. You're introducing something into their body. In this case, there was a knee on George Floyd's neck. So they're saying he physically assaulted them that resulted in the death. So there are these different legal doctrines that are complicated, and a lot of attorneys are trying to flesh it out right now. Jonathan Turley's trying to flesh it out. My understanding here, Ma, specifically to your question, is we need more details about. I think this is what your question is. You didn't say it in your question, but I think it's specifically applicable to the George Floyd case, the Derek Chauvin trial. In which case, my understanding is that Minnesota has a weird sort of merger doctrine between the two. So the underlying predicate felony gets merged into the murder charge in a way that you don't necessarily need to. My understanding is it kind of doesn't fall into either category. The general distinction here on this question is that there are some jurisdictions in this country where the underlying assault sort of merges into, it becomes the underlying felony for felony murder, so you can still be charged with felony murder. In other jurisdictions, they say no, assault is part of murder. It cannot be a part of felony murder because you need an underlying felony. You need like a bank robbery in order for it to be felony murder. In this case, how can you be charged with felony murder and murder, which is the actual assault? Okay, Derek Chauvin was charged with killing George Floyd. Read the statute. But he's also charged with committing a felony that resulted in George Floyd's death, and he's being charged with felony murder for somebody dying while he was committing a felony. The question is, was the assault a felony that can be the predicate for the felony murder, or does that charge need to go away, and does it only need to be the regular murder charge? Ma, this question I could prepare like 30 slides on this question. But that's all we got time for. So good question. A lot of analysis on it. The point is he's being charged with 3 charges. And so I think we can just operate on that basis. I think a lot of the other stuff about merger doctrine and predicate felonies and all of those other things, I think it's largely academic at this point because the issue's been settled. We know what the 3 charges are. We know what the Court of Appeals said about the 3rd-degree murder charge. And we just got to sort of accept it at that. I don't think... Unless somebody's appealing stuff up to the Court of Appeals or the Supreme Court, I think that it's just academic at this point. But it is a good academic question. It's an interesting one, and my understanding is that Minnesota does it almost uniquely. Sort of there's 2 ways to handle it. Assault gets incorporated in. Assault does not get incorporated in. Here, Minnesota, I think, is sort of a mix between the two. It's like a modified merger rule, which is, it is what it is. All right, so good questions. Once again, those all came over from Watching the Watchers. Locals community at locals.com. Find our group called Watching the Watchers. Good questions today. Good questions. Challenging questions. I like them.